Secretary of State for the Home Department against MA Somalia.
May it please your Lordship and Ladyship, I appear in this appeal with my learned friend Miss Dot Jury for the Secretary of State for the Home Department, and my learned friends Mr Richard Drabble of Queen's Counsel and Mr Graham Denholm appear for the respondent MA. This is an appeal from a decision of the Court of Appeal. The Court of Appeal allowed the appeal of the respondent MA from the determination of the Immigration Appeal Tribunal, which I shall refer to as the AIT. I'm sorry, the Asylum and Immigration Tribunal, which I'll refer to as the AIT. And that decision was itself made by the AIT after a second stage consideration. Can I start, please, by setting out the structure of my submissions? Firstly, I'm going to say a little bit about the issues in the case. Then I'm going to give an outline of my submission on the points that we submit arise. And then finally, in 5 sections, I'm going to deal with what I'll call the building blocks, which we submit on examination will show that the decision of the Court of Appeal was wrong. So if I can start first of all with the issues. And can I apologise straight away for what may seem to be a disconcerting amount of factual appeal on what is an appeal on a point of law. However, we say that that is a function of the error into which the Court of Appeal fell. Now, in my oral submissions, I will aim to keep the investigation of that factual material to the bare minimum which is necessary in order to understand the issues. Despite the apparently factual character of the documents, we say that the appeal does raise some important legal issues, and I will now explain what those issues are. Now, the case is not about the substantive law relating to Article 3 risk. That was not in dispute at any stage in the course of this case. It's accepted that if protection would not be available to the respondent MA on return to Mogadishu, then he would be at real risk of ill treatment breaching Article 3. The issue for the AIT in this case, rather, was whether he had shown to the applicable standard that he would be at such risk. Now, the issues on this appeal, we say, concern adjectival law. In other words, firstly, what rules, if any, constrain a fact finder in a case like this? And secondly, what rules constrain an appellate court, whereas is the case here, the appeal is on a point of law only. Starting with the issues concerning the fact finder, the Secretary of State makes a broad and a narrow submission. The broad submission, and I'm just outlining it at this stage, is that the assessment of Article 3 risk is a pure question of fact. The narrow submission is that where an appellant has told lies, or more euphemistically, failed to give a credible account in relation to an aspect of his claim for international protection, the law permits, but does not oblige, the fact finder to give that lie weight in the assessment of risk. Now, what weight is given to the lie is a matter of fact for the fact finder. And can I, at this stage, right at the beginning, emphasise a point that is made in paragraph 120 of the Secretary of State's printed case, and it's this: the narrow submission should not be confused with an argument that a person who lies should be penalised for lying, and it should not be confused with an argument that once a lie has been detected, the fact finder is bound to reject the claim. And I'll come back to those points and expand them in due course. Moving on to our submission about the role of the appellate court, in short, and I apologise for the triteness of this proposition, it's not permitted on an appeal on a point of law to interfere with the lower tribunal's assessment of the facts. Now, we say that this applies whether this court accepts our narrow or our wider submission in relation to the role of the fact-finding tribunal. Our submission, in short, is that whichever of those two submissions, the narrow or the wide, is correct, the Court of Appeal in this case interfered impermissibly with the tribunal's assessment here. And when I come on to make my more detailed submissions about this, can I just apologise in advance for their triteness and lack of novelty. Now, before I start to explain what our submissions are in more detail, both sides in their printed cases have spent quite a lot of time on an exposition, both of the decisions of the Court of Appeal in this case and of the decision of the Court of Appeal in GM Eritrea. And the Secretary of State has also referred to a line of authority in the Court of Appeal following GM Eritrea. Well, what's the relevance of all this? Well, we say, in a way, the relevance is rather limited, because, of course, we accept that this court is not constrained by the approach of the Court of Appeal in other cases, and this court should not adopt that approach unless this court considers that that approach is right in principle. So, in relation to the narrow submission, we recognise that our task is to satisfy this court that the approach for which we contend is right as a matter of principle, and not merely that it is consistent, as we submit it is, with a line of Court of Appeal authority. So if I can turn now to the Secretary of State's submissions in outline. Now, what we've done to draw the threads together is to prepare a short note which should be on your tables at the side. I don't know where they've been put. Sorry, at the little tables at the side of the bench, there's a little pile of materials. Yes. And the top page is just a couple of sheets of paper, well, one sheet of paper, the back sheet, which just sets out our submissions in outline. Now, they've been set out in what is the logical order, in other words, starting with what we say the approach of the fact finder should be, and then moving on to the approach of the appellate court. But since I anticipate that little of what we say in relation to the approach of the appellate court will be controversial, can I perhaps ask your Lordship and Ladyship to look at that section of the note first, please? So we make 5 points in relation to the approach of the appellate court. Firstly, for paragraph 2 of the note, the assessment of whether a danger is sufficient to involve an infringement of a convention right is a question of fact for the fact finder. And for that purpose, we rely on a decision of the House of Lords, presided over by my Lord Phillips, in a case called RB Algeria. And if that proposition is controversial, I will take your Lordships and Ladyships to the passage in a moment. The second proposition is that the tribunal's decision must be read as a whole. The third is, and this will ring a bell because it's taken directly from a passage in my Lady Baroness Hale's judgment in AH Sudan, which we set out in the printed case. The appellate court should start with a presumption that the tribunal got the law right. Fourth proposition, that presumption is rebutted if the appellate court can detect a clear and material misdirection of law. And I've put there to be expanded orally. I just want to make three subsidiary points. Firstly, we submit the presumption is not rebutted if the appellate court has misgivings about the way in which the decision is expressed or structured, absent such a misdirection. Secondly, we submit it's not rebutted because a factor which the appellate court considers relevant has not been given the prominence which it is thought by the appellate court to merit. We submit that weight is a matter for the fact finder, and just because something hasn't been mentioned expressly or not in depth, it doesn't follow that it has been left out of account. We also submit that the presumption is not rebutted if the appellate court is uneasy about the outcome or would itself have reached a different view on the facts. Because as we all know, there are many factual issues about which rational fact finders can disagree without erring in law. And then the fifth proposition is that absent a clear misdirection, an appellate court can only interfere if the lower court had regard to irrelevant matters, failed to take account of relevant matters, or was otherwise irrational. And the test is sometimes expressed, the Edwards and Bairstow test, in the language, in brackets, no reasonable tribunal properly directed could have come to that view on the evidence. And we say, in connection with Proposition 5, that that type of case in this jurisdiction will be a very rare case indeed. And in effect, the basis on which the Court of Appeal interfered with the AIT's decision in this case, we say, on analysis, it can only be because actually they considered the decision to be irrational. So, drawing the threads together, the Secretary of State submits that if these propositions are correct, and that's whether the wide or the narrow submission is accepted in relation to the AIT's function, an analysis of the relevant materials in this case will show, firstly, that the conclusion of the AIT was open to it, and secondly, that the conclusion of the Court of Appeal was not. And in order to support those submissions, I will now refer as shortly as I can to the material that I referred to a moment ago as the building blocks. And there are really 5 things that need to be considered here. The first is the approach that should be taken by a fact finder in assessing a breach of a convention right, in this case Article 3 risk. Secondly, the country guidance case that was relevant here, which is the case of AM and AM. The third building block, and the most important in my submission, is the decision of the AIT in this case. The fourth building block is the decision of the Court of Appeal in GM Eritrea, and the fifth is the decision of the Court of Appeal in this case against which we appeal. So if I can turn to the first building block, which is the assessment of future risk in a claim for international protection. Now, when I use the phrase international protection, what I mean is either a claim by an appellant to be a refugee under the Refugee Convention, or a claim under the European Convention on Human Rights that return to his country of origin will involve a breach of Article 3 by the United Kingdom. Because in our submission, both types of claim raise a similar exercise, which is that the fact finder has to assess future risk. And we say that in both types of case, the fact finder is engaged in a similar kind of task. Now, this case is an Article 3 claim only, because for reasons which are explained in the printed case and which needn't detain us now, the respondent in this case did not have a claim under the Refugee Convention. But although the issues in this case concern Article 3 risk, we say that logically similar issues arise in relation to the Refugee Convention. And it seems from reading the printed cases that the respondent accepts that both types of claim require a fact finder to assess risk in a similar way, because the respondent helpfully points out that they accept paragraphs 1 to 41, I think it is, of the Secretary of State's case. And that includes our analysis of the assessment of risk. So I'm going to take this part of the argument quite quickly, since it doesn't appear to be controversial. Can I start with a claim under the Refugee Convention and ask your Lordships and Ladyship to look at Siva Kumaran, which is in volume 4 of the authorities at tab 28. Now, this was a case involving 6 Tamil asylum seekers, and the principal issue was what was meant by the phrase well-founded fear of persecution when it occurs in the Refugee Convention, and in particular, was that test objective or subjective? But a further issue on which the House of Lords gave guidance was the standard of proof. If I could just take Your Lordship's notice very quickly to the relevant passages, can I ask you to look first of all at page 994G to 995B in Lord Keith's speech.
Sorry, could you give me the page again?
I'm so sorry, my Lord. It's page 994 in the speech of Lord Keith.
Yeah.
And it might just be quicker if I ask you to read the passage over to yourselves. It begins just below letter F on page 994 and finishes at letter C on page 995.
Has it ever been held at this level that the approach to Article 3 cases under the European Convention on Human Rights should be the same?
Well, we deal with that in our printed case. As far as I'm aware, no.
That's what I thought.
Yes, the position is that there's Court of Appeal authority that the test should be the same in MB Algeria.
But does the answer to this case really depend upon that?
Yes, I suppose it does. I mean, the answer to this case depends on what is the right test and how a fact finder should apply it.
Well, the right test is not going to be any more generous to the claimant than the one under the Refugee Convention, is it?
No, it's not.
It might just possibly, if one looked carefully at the Strasbourg jurisprudence, be different in the other direction.
Yes.
I'm not suggesting that it is,
No.
because you're not arguing about that.
No, I'm not.
But
that possibility
do you
exists,
want
yes,
this
I
court to
recognise
hold positively that the test is identical without it being argued?
Well, the safer position might be to say it wasn't in dispute. There's not an issue in this case. I mean,
It doesn't, well...
It doesn't seem to be an issue in this case at the moment. Well, can I give your ladyship's question some further thought, if I may? Can I then ask your lordships and ladyship to look at a very short passage in the speech of Lord Gough on page 1000 between letters F and G, where he summarises his understanding of the position. And he says this: first, I respectfully agree with my noble and learned friend Lord Keith for the reasons given by him, that the requirement that an applicant's fear must be well founded means no more than that it has to be demonstrated to a reasonable degree of likelihood of his persecution for a conventional reason. Indeed, I understand Mr. Law's submission that there must be a real and substantial risk of persecution to be consistent with this interpretation. So that's a sort of condensed version of the passage in the speech of Lord Keith.
Is there anything in this case which throws any light on the question whether that applies to all aspects of the factual inquiry? For example, they're talking about a risk of persecution by reason of race, religion, nationality or political opinions at page 994 in the... Now, is race, religion, nationality, political opinions, all matters about which the applicant must know, a matter which is to be assessed as a matter of risk, or is it being an existing fact, a matter which is to be assessed as an existing fact within the applicant's knowledge? Is it a matter to be assessed on a balance of probability? Supposing you had a Tamil, he might be a Tamil from Sri Lanka, he might be a Tamil from South India. Supposing there was no evidence, his evidence was completely discredited, and you would say, well, there's a reasonable possibility he comes from Sri Lanka. If so, he would be liable to persecution if returned there. But is that sufficient?
Well, to deal with the question which your Lordship asked, first of all, which is whether there's any discussion of those issues in this case, the answer is no. Those sorts of issues are, however, discussed in the next case to which we refer in our printed case, which is Karanakaran, which is a Court of Appeal decision. But there's not. This case was really about the broad level of the general issue of principle rather than detailed issues of how the fact finder should go about this task. Sorry. So that brings me on to the next case, the next important case in this context, which is Karanakaran, and that's in volume 3 at tab 19. I think for current purposes, again, because this doesn't appear to be in dispute, it may be quickest, if at this stage I simply ask your Lordships and Ladyship to read paragraphs 1 and 2 of the head note, and not to be deterred from reading paragraph 2 by the first sentence, because there is relevant material further down in that paragraph of the head note. I don't know if you...
Yes.
It may assist in the light of my Lord Mance's question if I took your Lordships and Ladyships one or two passages in the judgments of Lord Justice Brooke and Lord Justice Sedley. But for the third member of the court was Lord Justice Robert Walker, as he then was, and he agreed with both judgments, and Lord Justice Sedley and Lord Justice Brooke agreed with one another. So effectively, passages in either judgment have the authority of the full court. Just to see how this works in practice, can I ask your Lordships and Ladyships look first of all at a passage at the foot of page 459 in the judgment of Lord Justice Brooke, and who's there discussing what he says is the true effect of a decision of the majority in a case called Kaya, a decision of the Immigration Appeal Tribunal. He says that what the head note in the report about it says is wrong, and then just below letter H he says this: what they decided was that when assessing future risk, decision makers may have to take account of a whole bundle of disparate pieces of evidence. 1, evidence they are certain about; 2, evidence they think is probably true; 3, evidence to which they are willing to attach some credence, even if they could not go so far as to say it is probably true; 4, evidence to which they are not willing to attach any credence at all.
How do you take that into account?
Well, no one's suggesting it's a difficult. It's an easy thing to do. In fact, it is a difficult thing to do. But the point about what this authority tells us about the assessment of future risk is that the fact finder will be faced with a mass of material of varying degrees of cogency, and the effect of this decision is that the decision maker has to take it all into account, unless it is evidence to which the decision maker is not willing to attach any credence at all. But
Yes, I was only nitpicking a bit because Lord Justice Brooke says you've got to take into account 1, 2, 3 and 4, and 4 is evidence to which you're not willing to attach any credence at all. I don't see how you can take
No, I don't think so. I'm so sorry, but I don't think that's what Lord Justice Brooke is saying at all. I think if you read the next sentence, the effect of Kaya's case is that the decision maker is not bound to exclude category 3, and I think it follows sub silentio that he can exclude category 4.
have to weigh would have been better than take into account.
I think your Lordship's right. Your Lordship's absolutely right about that. It's perhaps not as clearly expressed as it might be. But if I could then ask your Lordships and Ladyship to go to page 469.
The view that you give it such a wide scope seems to be based on the feeling that was decided implicitly in Siva Kumaram. Look at little f on page 459. To say that it's only the facts established as more likely than not to have occurred on which the reasonable likelihood must be based would be, they said, to remove much of the benefit of uncertainty conferred on the applicant through Siva Kumaram. Well, I mean, you said yourself that Siva Kumaram doesn't actually throw any light on that problem at all.
Well, perhaps an indirect and rather wavering light, in the sense that what Siva Kumaram does make clear is that the question to be decided is whether there's a reasonable chance, the various formulations that you saw, rather than that somebody actually has to prove something on the balance of probabilities. I think that may be the point that
but Siva Kumaram is dealing with future risk, isn't it?
Yes. Well,
it's dealing with degree of risk.
Yes.
Yeah.
Not how you establish that.
Yeah. But Lord Justice Brooke's analysis seems to be that it follows from the degree of risk that you have to establish, that the way in which a fact finder should look at it is by looking at disparate bundles of evidence in the way that's suggested.
Well, as this case isn't about this, as you acknowledged at the outset, I'm not sure that we should be getting into this, but it doesn't follow. Because later on at page 469, which you're about to take us to, Lord Justice Brooke says that the House of Lords' approach to the assessment of future risk in children cases in Re-H doesn't apply.
Yes.
Now, the degree of risk in children cases is just about exactly the same as the degree of risk in asylum cases, i.e. a serious possibility that you can't ignore.
Yes.
Not necessarily a risk that it's more likely than not to happen. And yet the House of Lords held in Re-H that the facts from which you conclude that such a degree of risk exists should be established at least on the balance of probabilities, and that has been upheld by unanimous courts subsequently. So it doesn't. The two things don't follow, is what I'm trying to say.
I think there may be a distinction between cases that arise in a purely domestic context, where what is at issue is the rights of UK citizens or residents in the UK intercede, and cases such as asylum cases and Article 3 cases, which raise a question of compliance with an international convention. And in fact, that's the point that Lord Justice Brooke makes at page 469 at letter G, where he says, in the present public law context, where this country's compliance with an international convention is an issue, the decision maker is, in my judgment, not constrained by the rules of evidence that have been adopted in civil litigation, but is bound to take into account all material considerations when making its assessment about the future. So I entirely accept what your ladyship says about the characterisation of the risk, the similarity or identity in the characterisation of the risk issues in both types of case, but would respectfully suggest that it may be that the context makes all the difference to the way in which the fact finder goes about deciding whether the risk has been established or not. Because after all, in a domestic context, a conclusion about risk may lead to a parent being deprived of contact with his or her child, and that's quite a serious consequence. But in this context, precisely because if the risk materialises, that the consequences can be more severe. In other words, if the risk materialises, you send
if the risk of abuse of a child materialises, the child may die. We're talking about exactly the same sorts of problems.
Yes. Well, yes, I see your ladyship's point. Well, maybe the answer is, if it is an answer, that there's an extra layer here, which first of all is that it is not litigation into parties, it's not litigation between parents, and secondly, it's a public law context where compliance.
So was REH a public law context. I mean, this is the more serious thing, surely, Ms. Lang, is that it's very difficult to prove facts by ordinary evidence.
Yes.
When you have fled your country of origin and all the evidence that you might have to bring is not there. But that doesn't bear, I mean, that just merely asks the fact finder to be understanding of the difficulties.
Yes.
And be prepared to find that certain things exist when maybe they wouldn't be in the domestic context, because they will be saying, well, if you really were going to be able to prove this, you'd be able to do this, that and the other.
Yeah.
But we seem to have slid from one to the other, imperceptibly.
Yes. Well, I see the point your ladyship is making. I'd like to give that some further thought.
Do decision makers really apply the test at 469J? In other words, if an applicant contends that relevant matters didn't happen, but actually, one should start at H. It's because there are two sides of the coin. If he contends that matters did happen, you must take them into account unless you're clear beyond reasonable doubt that they didn't. And likewise, if he contends they didn't happen, you should take them, not exclude the possibility they didn't happen, unless beyond reasonable doubt you're satisfied beyond reasonable doubt that they did happen. I mean, do tribunals really direct themselves, leaving that enormous gap in the middle, and only exclude from consideration facts, past facts, unless they're satisfied on the criminal standard that they either did or didn't happen, as the case may be?
Yes, I see why your lordship is referring to the criminal standard, because the use of the phrase "no real doubt" that they didn't in fact occur. But I'm not sure that in practice decision makers do apply the criminal standard.
I mean, it seems to me it becomes a floating universe. The number of facts in play must be enormously increased by this approach if one's talking, as one often is, about account of past events.
Yes. But for the reasons that my Lady Baroness Hale gave, of course, part of the difficulty and part of the reason for this approach is that if somebody has fled to this country either to seek asylum or because they fear Article 3 ill treatment, it may be very difficult for them to have armed themselves with convincing proof that various things didn't happen.
As my lady said, you're not expecting them to do the impossible, and
No.
Their evidence has to be assessed with sympathetic understanding for the fact
Yes.
that they're not going to produce documents to back it up.
Yeah. I think
most
that's right. But I mean, essentially, what the Court of Appeal are saying in this case, as I understand it, is that there are a number of different pieces of information which a tribunal in this jurisdiction will be faced with when making a decision. They will be pieces of material with varying degrees of cogency. They're all relevant to the exercise. I mean, if one goes down to the passage over the page, on page 470, between letters, just above letter C and letter D, where Lord Justice Brooke endorses the approach of the High Court of Australia in Wu Shan Liang's case. Needless to say, when assessing the future, the decision maker is entitled to place greater weight on one piece of information rather than another, has to reach a well-rounded decision as to whether in all the circumstances there's a serious possibility of persecution for a convention reason. And then there's the internal relocation issue. Balancing exercise may necessarily involve giving greater weight to some considerations than to others, depending variously on the degree of confidence the decision maker may have about them or the seriousness of their effect on the asylum seeker's welfare if they should in the event occur. I mean, there's no getting away from the fact that this is a very, very complex exercise. Can I then ask? I'm so sorry. Can I then ask you to look very quickly at Lord Justice Sedley's judgment? It might be easier if I just ask your Lordships and Ladyship to read the passage, the paragraph that starts just above letter B on page 479, and which ends just above letter F on that page.
Well, what was the precise parameter of the?
Sorry, my lord, it's the paragraph at the top, the first entire paragraph on page 479.
Yes.
And then the final paragraph of Lord Justice Sedley's judgment, which begins at the foot of page 479, where he says it may be necessary to approach convention questions in a discrete order, but how they are approached and evaluated should henceforward be regarded not as an assault course on which hurdles of varying heights are encountered by the asylum seeker, with the decision maker acting as umpire, nor as a forum in which the improbable is magically endowed with the status of certainty, but as a unitary process of the evaluation of evidential material of many kinds and qualities against the Convention's criteria for eligibility for asylum. And
the cases cited are cases where, I mean, I'm just looking at one or two of the quotes. They seem to be dealing with a situation where you've got a whole lot of circumstances, some of which taken by themselves would not raise more than a slight possibility, but in conjunction with others, there enough to show a real chance of persecution?
Yeah.
That's entirely conventional thinking, isn't it? That's where the ultimate question is one of future risk. You can put together a number of factors cumulatively,
Yeah.
but it's not quite so easily applied to an existing fact, such as ethnicity or religion,
No,
or a past event.
I see that, but that was one of the issues that the Court of Appeal was grappling with in this case, and it's an issue on which they differed from another division of the Court of Appeal in Horvath. So there's some discussion of that approach, which was the approach that was adopted in Horvath, and it's an approach that the court in this case decided wasn't right.
But there is no authority that you can show us which says that in relation to some existing fact,
Yes.
The standard of proof is the balance of probabilities, or is there?
No. No, I think that's right, because that was the difference between the Court of Appeal in Horvath and the Court of Appeal in this case, and they differed on that point. The next point is just to show your lordships where this approach has been applied.
What did the House of Lords say in Horvath about it?
From recollection, it wasn't an issue for the House of Lords. I think
I think it wasn't. I mean, I was the other person in the Court of Appeal in Horvath. So.
Yes, I don't think it was an issue in the House of Lords. And then the next point, really, on this first building block is just to establish that this is the approach that's been applied by the Court of Appeal in the Article 3 context, and that's the MT Algeria case. I'm not sure I need to take the court to that, but the Court of Appeal has said that this approach should be applied, the civil command approach, when the question of future risk under Article 3 is at issue. Can I then turn to the second building block, which is the country guidance case, in this case AM and AM. In our printed case at paragraphs 23 to 26, we set out an account of the tribunal's practice of giving country guidance decisions, which is now a well-established practice. I'm not sure it's necessary to take the court over that material. Can I just refer the court to a decision of Mr. Justice Ousley, who was the last president of the Immigration Appeal Tribunal in MN Lone Women Ashraf, Somalia, which is at tab 25 of volume 3. And in paragraphs 135 to 143 of that decision, he gives a very careful and illuminating account of what the purpose of the country guidance decision is. And the point that he emphasises is that they aren't factual precedents. Now, before I ask your lordships and ladyship to look at the country guidance case that was material here, can I mention a very important part of the Court of Appeal's decision in this case? It's the one feature of the Court of Appeal's analysis with which we agree with respect, and it's that at paragraph 110 of its decision, and that's at page 34 in the core volume, sorry, part 1 of the appendix. The Court of Appeal rejected a submission that was made on behalf of the respondent, the appellant as you were at that stage, that the tribunal had failed to understand the significance of the country guidance decision. The submission recorded in paragraph 110 was that the AIT could not properly conclude in the light of the country guidance decision, as they did in paragraph 109, that it was not fanciful to say that the appellant may not be at risk on return. And the Court of Appeal reject that submission. We say that's very important because what it shows is that the Court of Appeal accepted that just looking at the general evidence in the country guidance decision, it was entirely possible, to use the phrase that's used in GM Eritrea, that the respondent could get protection in Mogadishu. So it all turned on an appreciation of the individuating factors in his case. So in the light of that, we say, very important part of the Court of Appeal's analysis, it really isn't necessary to spend very much time on the country guidance case. It's at volume 2, tab 9 in the authorities.
What I don't understand is, just looking at the previous cases, if the test were as set out in the Court of Appeal in Karanakaran, and you say that's been applied to Article 3 in MT Algeria, then it shouldn't be sufficient for the tribunal to say that it's the point is that it's not fanciful to say that he would not necessarily be at risk on return. The tribunal ought to have been making a finding, if it was to reject this claim, to the effect that we find positively that there is no real risk that he would be at risk on return.
Well,
which is rather different, isn't it?
I entirely accept it's different. This is, as it were, the first stage of the argument. What I'm relying on this passage to show is that the Court of Appeal accepted that on the general evidence alone, it was possible that the respondent could have got protection in Mogadishu. So, in the light of that, the only issues for the Court of Appeal were, firstly, whether the AIT had left something out of account in its own assessment, which it should have taken into account, or whether the only tenable view, taking into account all relevant material, was that the respondent's claim must succeed. But the first step is to see what the background material establishes. And I'm simply relying on paragraph 110 of the Court of Appeal's decision to show that they accepted that the first step was that on the basis of the in-country material alone, his claim could not succeed, because it was possible that he could get protection. So the issue for the AIT was, the issue is, did the AIT make their assessment on that issue correctly or not? If I can then ask you to take up AM and AM, it's a slightly different case from this case. There were two appellants, both called AM. Both were Somali citizens. One was from Mogadishu, the capital, and the other was from Johar. And they brought appeals based on the Refugee Convention, Article 3 of the European Convention on Human Rights, and Article 15C of the Qualification Directive. The AIT decided their appeals, and in doing that, it looked at a mass of objective evidence about the then current situation in Somalia, and one can get a sense of how much they looked at just by glancing at the last few pages of that tab, starting at page 68. Pages 68 to 84 are taken up with a list of the various objective materials that they looked at. Now, I'm only going to take you to a very few passages in this. First of all, it's important to note at paragraph 4 that the AIT in this case decided not to hear any further evidence from either of the appellants. There was an application on their behalf for further subjective, in other words, evidence from the appellants to be admitted, and that application was declined. So the position was that the AIT in this case did not hear evidence from either appellant on current protection issues, and wasn't in a position to evaluate any evidence on that. They were content to deal with the findings that had previously been made on those issues by earlier divisions of the AIT. And there had been earlier adverse credibility findings in relation to both, but those adverse credibility findings concerned their claimed past experiences in Somalia. They were nothing to do with the issue of protection on return. Paragraph 7, one sees the few facts that were accepted in relation to AM2. He's a Somali, a member of the Sheikh al-Lagobi clan, and he's from the Hamar Jahid area of Mogadishu. And at the date of the hearing on the 20th of July 2007, was still in contact with his mother and brother, and indeed with clan members with whom the latter were staying in Mogadishu and from whom they were receiving protection. So those were the factual findings on which the AIT proceeded in that case. Now, my learned friends make the point in their printed case that this is a weaker case for the appellant than is the current case. We don't accept that analysis. The suggestion, obviously, is that if AM2's appeal succeeded, well, then so should MA's. But that suggestion is misconceived, we say. And briefly, the reason it's misconceived is because the crucial difference between the two cases is that in this case, in our case, the appeal was remitted to the AIT specifically for them to consider two issues: internal relocation, firstly, and protection in Mogadishu on return. And the AIT, in our case, specifically investigated those issues and heard evidence from the appellant on them, and held that the appellant was telling lies in relation to the issue of protection. And we say, and we hope it'll become clear why that's significant when I come to make my further submissions, we say that's a critical difference between this case and that. And we say that on the evidence that was before the AIT in relation to AM2, it was open to them to find, as they did, that there would be no protection available to him on his return because of the disruption that had occurred between 2007, which is when the last factual findings about his case were made, and the position as at the date of the hearing. If I could ask you to turn very quickly to paragraph 152 of the decision, just to give you the flavour of what was going on. We see there that the AIT note that estimates of the numbers displaced from Mogadishu vary from around 400,000 to 750,000 people. And if one goes to paragraph 171, just to put that figure in perspective, one sees that the population figure for Mogadishu is rather uncertain, and depending on the sources, it varies from between 1 and 2 million. So those are the figures about displacement. If I could then ask Your Lordship to note paragraph 162, which deals with the relevance of clan matrix and loyalties. And the submission that was made on behalf of the appellants is in the inset passage. The tribunal should find a reasonable likelihood that membership of a clan doesn't by itself protect an individual. There's then extensive reference to the evidence relied on for that contention. And at paragraph 164, they say they don't doubt that recent events have altered the character and dynamics of clan and sub-clan activities to a significant degree. Compared with the early 1990s, clan protection is no longer as effective as it was. But they go on to say this: we cannot agree with Mr. Toll, counsel for the appellants, that the clan or sub-clan has somehow ceased to be the primary entity to which individuals turn for protection. They then give 3 reasons for that conclusion, one of which is that there's ample evidence, But in terms of the use of arms, basic units who carry arms continue to be, at least on the insurgent side, clan-based or sub-clan-based militia, and there's reference to further evidence on that, and closely interrelated is emerging evidence of resurgence of clan-based militia activity. And then they say, we think the preponderance of the evidence is crystallised in the words of Matt Bryden. Clans remain important, but are no longer able to provide the level of protection or support that they used to. And then of significance is paragraph 165, the next paragraph, which is that the most recent evidence relating to Mogadishu is that the civilian population is now largely rearmed and has begun stocking ammunition. And they go on to say, we think it's highly unlikely, this is the TFG and the Ethiopians, would be any longer in a position to prevent local populations or key sections of them rearming and doing so much of the time on a clan basis. Paragraph 167.
I imagine Mr. Drabble wants you to read 166.
Yes. Right, so far as the position of minority clans is concerned, neither party asks us to take a different view from that taken in HH, save in respect to their situation as civilians and or IDPs. We'd only note, so far as Mogadishu is concerned, that whilst it appears that a significant number of minority clan or group members have chosen to stay on in Mogadishu, some from other areas have even moved to there. We go on to find below that the situation in Mogadishu for the great majority of residents is currently precarious. In our view, the situation of minority clans in Mogadishu would be a fortiori precarious. Just pausing there, though, the position is slightly more finely graded than that, because when the phrase minority clan is used in the country guidance decisions, what is being referred to is a clan which is in a minority in Somalia as a whole. The clan to which the respondent in this case belonged is, in terms of numbers, in a minority in Mogadishu, but it is not a minority clan. It's a majority clan. And that difference, I'll take your lordship's notice to it in a minute, is reflected in a passage in the AIT's decision in this case. Paragraph 167, there's some discussion of the position of the clan to which AM2 belongs. They used to have protection from the Hawiye, who were the majority clan in Mogadishu. Paragraph 170, less able to get protection than formerly. Much will depend on the particular circumstances of clan members. Paragraph 170. And of course, one notes that the AIT in AM2's case had already decided not to investigate those any further. If I could then ask you to look at paragraph 173, the AIT attach some weight, although I think perhaps not great significance, to the evidence indicating that in certain areas of Mogadishu, where the more affluent live, they are able to afford strong personal protection. And then they refer to numbers of people who have fled from elsewhere to Mogadishu. So that's paragraph 173. In paragraph 174, a situation many sources describe as anarchical, difficult to gain a precise spread of the picture of violence in Mogadishu. They then go on to summarise the evidence in relation to that. And then towards the bottom of the paragraph, whereas the northern parts of the city, which are said to contain the most affluent districts, have been relatively unaffected, in January 2008, OCHA reported that IDPs were leaving areas of Mogadishu hitherto considered relatively safe, such as the large northern suburb of Dainila. And then there's mention of fighting in Helua, Kararan and Hariwade of northern Mogadishu. So that's the position about where the fighting is happening. We then have the in paragraph 175, they talk about the level of violence, and they say that the violence in that city has exhibited particularly dire features over a concerted period of time. Its nature has become increasingly indiscriminate in the sense that different armed groups involved in the fighting routinely fail to distinguish between civilian and military targets and use disproportionate methods. I could then ask you to look at paragraph 178, which is a passage that will be very familiar to the court, no doubt from having read all the papers in this case. The key point there is that on the present evidence, they consider that Mogadishu is no longer safe as a place to live for the great majority of its citizens. We do not rule out that, notwithstanding the above, there may be certain individuals who, on the facts, may be considered to be able to live safely in the city. For example, if they are likely to have close connections with powerful actors in Mogadishu, such as prominent businessmen or senior figures in the insurgency, or in powerful criminal gangs. However, barring cases of this kind, barring cases of this kind, we consider that in the cases of persons found to come from Mogadishu who are returnees from the UK, they would face on return to live there a real risk of persecution or serious harm, and it's reasonably likely if they tried staying there, they would soon be forced to leave, or that they would decide not to try to live there in the first place. So, and that's emphasised where they give their conclusions in relation to Article 15C of the Qualification Directive in paragraph 179, where they say it's unnecessary on the facts of this case to rely on such additional scope, since return to that city for the great majority would amount to a real risk of persecution, serious harm and ill treatment. So it's no doubt, because of the way that the Court of Appeal read those passages, that the Court of Appeal concluded that the in-country evidence did not show that a person who returned to Mogadishu would be unable to get protection. What it shows, we say, is that for the majority, unless they could get protection, that would be the position, but that certain categories, which are not exhaustively stated in paragraph 178, of people are able to get protection, notwithstanding the dire conditions in which Mogadishu was at the time of this country guidance decision. Their assessment, I should just take you very quickly to their assessment of AM2's case, which is at paragraph 208. And their assessment is that, although he's relatively young and able-bodied, they see nothing to indicate he's someone who'd be likely to have connections with powerful actors, such as prominent businessmen and so on. He had family members in the city at the time of the hearing of his case, but in view of the major displacement of the city's population since then, we think it's unlikely, even if they are still there, they are any longer in a position to protect him as they did previously. The fact that he and his family members are from the Sheikh al-Lagobi clan, which is not as such a majority clan, further decreases the likelihood he would achieve protection from serious harm in the city. And then they note the evidence from AC, who's a senior clan member of the Sheikh al-Lagobi, who put forward a witness statement to the tribunal. As a result of the events between 2003 and 2007, the Al-Shabaab, which is the main insurgent group, has come to perceive the Sheikh al-Lagobi adversely as TFG, that's Transitional Federal Government supporters. So that's an additional factor. And for all those reasons, they conclude that in his home area he faces a real risk. And we are also satisfied that the risk of persecution in his home area would have as one of its effective reasons his race or ethnicity in the form of his clan identity as Sheikh al-Lagobi. So, just to draw the threads together, we say, and the Court of Appeal held in this case, that the general evidence doesn't show that a claim under Article 3 must succeed if a person is being returned to Mogadishu, or to put it another way, the possibility that the particular facts may make a difference cannot effectively be excluded. And we also submit that when we come to look at the decision of the AIT in this case, which I'm about to do, we'll see that the AIT rightly interpreted AM and AM in just this way. Can I then ask your Lordships and Ladyship to look at the decision of the AIT in this case, which is in the core volume, and it starts at page 44. part 1 of the appendix. I'm just going to start by making 1 or 2 observations about a first instance determination in general. We submit that in a determination such as this, the tribunal discharges its legal obligation, to give reasons for its decision to dismiss an appeal. And at the time of this hearing, that obligation was expressed in Rule 22 of the relevant procedure rules. Now, the determination as a whole is both the result and the expression of the AIT's reasoning process, but it's also good evidence of the principal factors which the AIT had in mind. Now, as we all know, the obligation to give reasons is an obligation to explain to the parties why they won or lost by dealing with the main controversial issues. It follows, we say, that the AIT's reasons are not required or expected to be an exhaustive statement of every nuance of that reasoning process. And we say it is this understanding of the nature of a determination which informs the approach of the House of Lords in AH Sudan. But we say it is absent from the Court of Appeal's approach to the AIT's determination in this case. Now, can I ask you to take up the decision? And the first thing I'd like you to look at, please, is on page 44, under the heading Representation, against the word interpreter, one sees Mr. Fuad Mohammed was available to translate the Somali and English languages, but was not needed. Now, we say that...
Where was that paragraph?
I'm so sorry, my lord. It's page 44,
yes,
under the heading Representation, against the word interpreter. One sees that interpreter was there, but was not needed. Now, we say that this is an important factor because in many cases where the appellant is a Somali or from another country, they won't speak English and their evidence will be mediated via an interpreter. And I don't know if any of your lordships and ladyship have ever been present when evidence has been given by an interpreter, but it's a laborious and slow process, and much is lost in translation. In this case, we say, the AIT was in a particularly good position to appreciate the demeanour and the answers of this appellant because he was giving evidence directly to them in English.
Forgive my curiosity, Ms. Lang. There's another remarkable feature under representation, that there were Queen's Counsel on each side. That's not a very common experience in the Asylum and Immigration Tribunal, is it?
It's not unknown, my lady.
I said it's not very common.
Well, I perhaps don't have enough experience to tell. I'm sure you're right. I'm sure it is unusual. But there it is. Now, the structure of the determination is that it's set out under a number of different headings. There's first an explanation for the delay in the promulgation of the determination, which has to do with the fire at Field House. There's then a recitation of the history. There is then the tribunal's self-direction on the burden and standard of proof, necessary for the appellant to prove his case. If he's to succeed, he must show there's a real risk of his suffering ill treatment of such severity that his rights under Article 3 be breached. Then a heading about opening submissions. There's then on page 50 a summary of, a pretty full summary actually, of the appellant's evidence. Then starting on page 56, there's a summary of the expert's evidence. And then, if I can ask you to turn to page 60, one has the heading submissions for the appellant. In fact, this section contains the arguments and the reasons for the determination, and one sees that if one reads paragraph 88, when we consider the submissions below, we also indicate our findings. We hope it's not necessary to say, but to avoid any possibility of doubt, and one may think, in the light of these proceedings, as a rather forlorn expression of hope, we emphasise that although we've indicated our findings when we have considered the submissions and in places the evidence, we did not make any findings until we had considered the entirety in the evidence of the round with the submission made. So that's paragraph 88. And could I then ask you to look at paragraph 105, which is an important passage. This is the passage that the Court of Appeal described as an impeccable self-direction. The tribunal is not unfamiliar with the difficulties created by appellants who have not been truthful but who may still be at risk. This was considered by the Court of Appeal in GM Eritrea. We must be very careful not to dismiss an appeal just because an appellant has told lies. Even if very large parts of his story have been disbelieved, it is still possible that the appellant has shown that he would be at risk on return. An appellant's own evidence has to be considered in the round with other evidence, and that can include unimpeachable evidence from expert reports or country guidance cases or other evidence about the general state of affairs in the country. And a similar point again is made at paragraph 107, where they say, we do not believe the appellant, but we have to decide if the background conditions show that he will be at risk. And then they set out paragraph 178 of the country guidance decision, which we've already looked at. Now, it's important to understand what the explicit purpose of this hearing was, and one gets that from paragraph 6 of the decision. On page 46 of the first part of the appendix. And there, the AIT set out in full the decision ordering reconsideration. I'd just like to take you very quickly to one or two passages in that. Paragraph 1, there's reference to the decision of the tribunal in November 2003, where they say they were satisfied that the appellant was prepared to mislead in order to secure the result which he sought, which was long-term residency in the UK. There's then a reference to the country guidance decision in NM and AG. The important point to emerge from this is that in the country guidance decision of NM, the point is made that telephone connections to Mogadishu are good. And that evidence was not in any way different in the country guidance case HH, in which the point was also made that telephone connections to Mogadishu, I mean, everybody these days has mobile phones, that's the point. Then the reasons why the reconsideration was ordered are set out in paragraphs 3 and 4. And the important point is that Mr. Herner, who's the respondent's expert, did acknowledge, however, that there had always been ISAC individuals and families in Mogadishu and that they could be reasonably safe if they were related to Hawaii through marriage or if they were related to dominant clan family in Mogadishu through membership of religious and economic organisations. He acknowledged there was a rather small ISAC community and they probably depended on protection of Hawaii friends, colleagues or in-laws. And then the AIT say in paragraph 4 that given the individual circumstances of this appellant, I am satisfied the tribunal made an error of law in failing to consider whether the appellant would be able to make arrangements for protection by the Hawaii through his connections with the ISAC. And then at the bottom of paragraph 4, over the page, I take the view that in this regard the appellant had at least an evidential burden which he failed to discharge, since what contacts and relationships he had was exclusively within his own knowledge and not that of the Secretary of State. So one of the reasons why this hearing was being held was precisely in order to investigate what protection, if any, would or might be available to the appellant if he were returned to Mogadishu. So everybody, including the appellant, would have known that that's what the AIT was interested in and why. If I could then just give you a few references from the AIT determination. First of all, paragraph 44, the AIT mentioned or record the appellant's evidence. Last sentence, paragraph 44. In 1994, he travelled to Kenya, and in 1995, he travelled to the United Kingdom. So his case about when he arrived in the United Kingdom is recorded in paragraph 44. There are several references in the body of the determination to the fact that he had been in prison in the United Kingdom. Paragraphs 35, 40, 59, 60, 61, 64.
Sorry, can you just go through those
Yes.
again, please?
35,
Yes.
40, 59, 60, 61, 64, and in paragraph 71 there's a reference to deportation, which, given the criteria for deportation, implies that he has been sentenced to imprisonment. So it's absolutely clear from the fabric of the determination that the AIT was aware that he had spent part of his time in the United Kingdom in prison. They also record his case at paragraph 37. He then said equally emphatically that he'd had no contact with anybody in Somalia and had not had contact with anybody in Somalia since he had been in the United Kingdom. Now, I said a moment ago that the duty to give reasons is a duty to give a decision on the main controversial issues. In this context, can I just make a point on the skeleton argument that was produced by the appellant for this hearing? It's in the appendix part 2, and it starts at page 153. Well, in fact, I'm going to make 2 points about it. Paragraph 10 on page 155 refers to the fact that the appellant was detained following the completion of his custodial sentence. And the points that are made, this skeleton argument was produced in response to the promulgation by the AIT of the country guidance case, AM and AM, to which I've just shown the court. So this skeleton argument is dealing with the relevance of AM and AM to the respondent's appeal. And what is notable about this skeleton argument is that the case that is being made can be seen from paragraph 20. The appellant has consistently maintained he has no knowledge of or contact with any family in Somalia. And then there are references to a number of pieces of evidence. He's produced a witness statement, paragraph 21, gives more details of his family history and the fact he's not currently in contact with anyone in Somalia. Paragraph 22, the tribunal is invited to find that the appellant has no family or friends in Mogadishu to whom he could turn for protection from the dominant clan groups. So that's as it were, the positive case that's being made. And there is nothing in this skeleton argument that draws specific attention to the 2 points on which the Court of Appeal relied in this case. In other words, to the point that it's implausible, it's impossible really for protection to be available to him, A, given the length of time he spent in the UK, and B, given the fact that some of that time, or for most of that time, he's either been serving his custodial sentence or been detained in immigration detention.
You mean paragraph 36?
Yes, paragraph 36 on page 163 follows on from a citation from paragraph 178 of AM and AM. There's no suggestion that the appellant has close connections with powerful actors in Mogadishu, nor are there any other factors which bring him outside the great majority of returnees, notwithstanding the issues relating to the credibility of aspects of his past account. If I could then just very quickly show the court the summary of the expert, the appellant's expert, Mr. Herner, which starts at page 56. The first passage I'd like the court to look at is at the bottom of paragraph 71, page 57. And this is picking up the point I made earlier in response to the passage from AM and AM that Mr. Drabble asked me to read out. Mr. Herner expressly agreed with Senior Immigration Judge Spencer that the ISAC are not in the same position as other minority clans because the ISAC are a majority clan in parts of the country but not in Mogadishu. They then quote various passages from the evidence, and the basic point I make about those passages is that there was nothing in those passages which excluded the possibility that protection would be available to the appellant. The passages are all passages that suggest it would be difficult, but they don't exclude it. The other point I'd like to make is based on paragraph 81 and 82 of the AIT's determination, where two passages are recorded. The situation of a newcomer in Mogadishu, I think there's a who missing, who belongs to the ISAC clan and has no long-standing personal connections to residents in the city, would therefore be very problematic and involve risk to fall victim to criminal or other violence prevailing in Mogadishu at the present. What I ask the court to notice is the premise on which that statement is based, and the premise is that one accepts that the appellant is in the position of someone who is a newcomer to Mogadishu and has no long-standing personal connections to residents. And then in paragraph 82, Mr. Herner addressed the following question: could an ISAC returning to Mogadishu without contact with anyone in Somalia since at least 1994 be able to arrange protection / support from the existing ISAC population there? And again, I ask the court to note the premise of the question, which is that the appellant is such a person, in other words, someone who has had no contact with anyone in Somalia since at least 1994. So again, that was a point in the case. It can't be said that the AIT were not aware that that was a point in the case. So, drawing all those threads together, we submit that the factors on which the Court of Appeal relied in paragraph 119 of their decision, which is the fact that he'd been away from Mogadishu for a long time and had been in detention for most of that period, were part of the factual matrix of this case. And as I've shown the tribunal, references to imprisonment and detention are woven into the fabric of the determination, and it's clear that the AIT were aware of the dates. Now, I fully accept that the AIT does not, in terms anywhere, refer to the length of detention in the United Kingdom. It's perhaps not surprising because it's not a matter that was relied on in the appellant's skeleton argument. It's not a matter on which particular stress was placed. As I've shown the court, the determination does refer more than once to the fact that he had been in prison and to the length of time he had spent away from Mogadishu. Now, in that situation, in our submission, it is simply impossible for the Court of Appeal to suggest, as they do in paragraph 119, that the AIT have simply left those factors out of account. What we say instead is that they may well have been factors to which the AIT did not attribute a special weight because they don't refer to them expressly, but it can't be said in the light of the fact that they are referred to in the determination that they are matters that the AIT did not take into account at all. And we say matters of weight are matters for the AIT and not for the Court of Appeal. And we say it is captures in the extreme of the Court of Appeal to suggest that the AIT must have ignored these factors, particularly given the submissions that they do record on behalf of the appellant. The first is set out in paragraph 94 of the AIT's decision, which is a submission that the AIT should find that the appellant has no family or friends in Mogadishu. And the second submission that they record is at paragraph 118 of the determination. And it's a submission that it was fanciful to suggest that the appellant came into any of the categories of people identified in paragraph 178 of AM as not being at risk. The appellant would be at risk in Mogadishu and his appeal should be allowed. Now, so far as the submission that the AIT should find that the appellant had, the respondent had no family or friends in Mogadishu, it is our submission that when one reads the AIT decision, it's clear that they found that he did. Can I just show you? It's paragraph 119 to paragraph 120. So, if one looks at the bottom of paragraph 119 on page 67, this appellant is going to be at risk if we accept his evidence of having no contacts there. We do not accept his evidence about that. He was manifestly untruthful. Now, we say that it's clear from that passage that the AIT were declining the invitation to find that the appellant had no family or friends in Mogadishu. And it follows, we say, that they were finding that the appellant did have friends or family in Mogadishu.
That's not right, is it? Just because you don't find something doesn't mean you find the opposite. You can have something which is not proven.
Well, we would say in the context of this case that apart from internal relocation, this was the sole issue that was being investigated by the AIT. When they record the course of the respondent's evidence, they record in a number of places examples of him being asked direct questions, giving evasive answers, going around in circles, backtracking, and being unhelpful. And we say in that context, this is a case where the AIT are to be understood as having found that he must have friends or contacts there. And as a matter of common sense, a person is not going to tell lies on this sort of issue if, in fact, if they told the truth, that was something that was going to support their case. So, as a matter of common sense, we say, in this passage, the AIT are finding that he did have contacts of some kind in Mogadishu. Can I ask you now to look at two of the passages that the Court of Appeal considered to be problematic in the decision?
I mean, just going back to how the Court of Appeal dealt with the detention point. I mean,
yes.
They didn't merely draw attention to the fact and rely on the fact that there was no reference to it, but they went on at 120 to say that the tribunal ought to have made an assessment on the basis of that evidence, that's to say the detention evidence, and had they done so, they must have concluded that there was a real risk. So they are, in effect, saying that a decision that if the tribunal had taken the detention point into account and reached the conclusion they did, then that was a perverse decision.
Yes, that's exactly what we're saying. We say that is wrong for two reasons. Firstly, they're trespassing into an area of factual assessment. But secondly, in any event, it's obvious nonsense because if the evidence about Mogadishu is that people are in contact with Mogadishu by mobile phones and so forth, there's absolutely no reason why the fact that you're in detention should mean that you can't be in contact either with members of your family who are then in contact with people in Mogadishu or directly with people in Mogadishu. And there are a number of references in the AIT determination which we collect. We can just give the references because they're set out in our printed case. Paragraph 132 of our printed case, we collect together the references in the AIT decision to, and this is on the appellant's evidence. The respondent's evidence. The references he made in that evidence to the AIT to the fact that he had relations in the United Kingdom, contact with his sisters in Belgium and Canada. He used to speak to his sister Kadra while serving his sentence. He's one of 12 children. He accepted he could contact his parents if he wanted to. And that's on his evidence. And we say in the light of the background evidence that mobile phone contact with Somalia and Mogadishu is perfectly feasible, it's frankly perverse of the Court of Appeal to say that this is a factor that must show that his claim should succeed. And with respect to the Court of Appeal, it illustrates the problems of diving into this area of factual assessment. I mean, I expect the Court of Appeal weren't aware of the background evidence about the fact that you can get in phone contact with Somalia. And this is a paradigm case of the sort of assessment that the AIT should be making rather than the Court of Appeal.
Can you just explain to me what you think that the Court of Appeal is saying in the last two sentences of paragraph 118 of its judgment?
Well, can I confess having had some difficulty in understanding paragraphs 118 and 119?
Well, 119 is if they did analyse the issue in that way. In other words, if they took the view that the only potential evidence was the appellant's rejected testimony, then they were wrong because they should have taken into account the lengthy period and the fact of detention. And paragraph 120 is the same thing. They ought to have done and must have concluded. But paragraph 118 says we can't infer that that was the only potential evidence. For example, there's no reference in the whole judgment to the fact that he spent the best part of the last 12 years in prison or administrative detention, which must have evidence, must have relevance. I simply don't understand the connection.
No.
They seem to be moving in opposite directions.
Yes, well, exactly. That's the difficulty I have with the passage. One infers from the conclusion of the Court of Appeal, in particular from paragraph 120, that what they're saying is they didn't take into account these two things, and if they had, then the appeal can only have succeeded. But the intervening discussion in paragraphs 118 and 119 is rather unclear because it's not apparent whether they are actually holding that the AIT did or didn't adopt a particular approach. But the general thrust of it seems to be that they're saying these two factors weren't taken into account, they should have been taken into account, and had they been taken into account, only one conclusion was possible. But in summary, our point about this is that in fixing on these two factors, showing that the AIT erred in law, the Court of Appeal itself fell into that very error. Can I ask your Lordships and Ladyships to look very quickly at two passages in the decision of the AIT which the Court of Appeal thought were problematic. And our basic point in relation to these is that the Court of Appeal misunderstood what the AIT was doing in these two passages. The first is paragraph 109 on page 64 of part 1 of the appendix in the core volume. Where they say, the difficulty is that the appellant has not told us the truth about his links and circumstances of Mogadishu, cannot exclude the possibility he is a person with connections of this kind. The point is that it's not fanciful to say he would not necessarily be at risk on return. Some people are not. Even though the appellant has to prove only a real risk rather than a probability of him being at risk, we cannot make the necessary findings when he will not tell the truth about his connections and contacts there. And then a similar point is made in paragraph 121 on page 67. I'll pick it up in the third sentence. The burden is on the appellant. He's not told the truth about his links with Mogadishu. We're not able to say that he is a person who has shown he would be at risk there. He has stopped inquiry of a kind that might reveal the links and protection he would have. He'd be very sad if by doing so he's deprived himself of the protection he would otherwise need, but he's told lies and must accept the consequence of that. It does diminish his credibility and makes it harder for him to prove his case. Now, in the second passage, we say that the right way of looking at the second passage, first of all, is that the AIT are not adopting as crude an approach as to say, because he's lied, he hasn't proved his case. That's clear, we say, is a matter of syntax from the use of the word and to connect the various clauses of the sentence. The burden is on the appellant and he has not told us the truth about his links with Mogadishu, and we are not able to say he's a person who's shown he would be at risk there. We say that that approach is lawful, whether we're right about the narrow submission or whether the court simply accepts the wide submission. The Court of Appeal was concerned by these passages. That's obvious from paragraph 117 of their judgment. I'll just ask you to look back at that. It's on page 36 of the core volume. Well, perhaps we should pick it up at paragraph 116, where they refer to those two passages. And they then say, we think with respect to the tribunal that is they're adopting the wrong approach. Their analysis suggests that the fact that the appellant has lied has of itself disabled them from reaching a conclusion on Article 3 risk. They seem to be throwing up their hands in despair. Since the appellant has concealed the truth, they cannot make any necessary findings. And then they refer to paragraph 121 in that context. Now, our submission is that when the AIT in paragraph 109 refer to necessary findings, what they are referring to is the findings which would flow from truthful evidence about the appellant's contacts. So if the appellant, rather than lying on that issue, had said, well, yes, I have an ancient granny in Mogadishu, but she's bedridden and is living in a bomb shelter, to take an extreme example, the AIT would have been able to assess that evidence. They would have been able to assess the character of his contacts and to see whether or not they were capable of giving him protection. So such evidence, if given, might well have enabled the appellant to succeed if he'd given evidence of the character that I have just described. Alternatively, if he'd given evidence of a different character, it would have made his claim fail. And so that's the first point. And we say that the AIT are making a similar point in the passage in paragraph 121, which the Court of Appeal also criticised. So the lies have stopped proper inquiry. In other words, the lies have prevented the AIT from assessing the nature of the links which they have found that the respondent has in Mogadishu. And because there is no evidence about what those links are, the AIT can't assess them and can't make positive findings on whether protection would be available or not. And it doesn't follow from either passage, and the AIT are not finding in either passage, that they were unable to reach a conclusion on Article 3 risk, because their clear conclusion on that is that the respondent has not shown to the applicable standard that he would be at risk. What the AIT is saying here simply is that the lie prevented them from making positive findings one way or the other about the nature of his links in Mogadishu. And on our case, a speculative finding to fill a gap left by a lie is not a necessary finding for reasons which I'll explain. Can I then leave the decision of the AIT in this case and go with
I'm trying to find it hard to envisage a situation where there would be an innocuous reason for there simply being no evidence on this point. But
yes. Well,
would you say the position would be exactly the same?
Well, it might. A fact finder might come to the view that the lie had been told for a reason which in this context was innocuous. So in other words, a person can tell a stupid lie thinking that the lie will help their case, whereas in fact it doesn't. So it would be possible for somebody to lie in this context and to say, I've got no contacts, thinking, well, if I say that, then I won't have to give further evidence which might go one way or the other. But they haven't necessarily lied for a reason that leads to an adverse conclusion.
Absent the lie, it would be, on the face of it, unlikely that this particular individual with his background would have the necessary contacts.
Yes.
So the lie puts in doubt what would otherwise be the natural conclusion one would draw.
Yes. Yes,
so
absolutely.
One is, as it were, attaching, if you like, negative evidential weight to the fact of lying.
Yes.
And that, you say, is something that any tribunal of fact
is perfectly entitled to
do.
They're not obliged to. It all depends on their overall assessment of the particular appellant and the reasons why
they haven't
quite
put it like that, have they? They haven't said, because he's lied, he really has raised grave doubts in our minds as to whether he falls into the majority. Somebody say, because he's lied, he simply made it impossible for us to assess because there's no positive evidence.
They haven't quite put it as crudely as that. No. Yes, if one looks at the final paragraph, my lord, paragraph 121, passage I read out a moment ago, they say, burden on the appellant and so on, stop proper inquiry. It would be very satisfied so doing the appellant has deprived himself of protectionalised need, but he has told lies and must accept the consequence of that. It does diminish his credibility and make it harder for him to prove his case. So we would submit that passage, particularly when read in the light of the impeccable self-direction of paragraph 105, shows that the AIT were not adopting a crude approach of saying, because he's lied, his claim must fail. Their approach was somewhat more nuanced than that. If I could move on very quickly to...
They certainly weren't saying that, but I mean, the way I must say I read it at the moment is to look at paragraph 109 and say that the tribunal thought that absent the lie, it was possible that he had contacts, and that possibility was sufficient to exclude a claim, unless there was evidence one way or other to show whether he fell within the majority or the possible minority.
Yes, I mean, what they're saying is that the background evidence shows that some people have protection. We don't think he's told us the truth about his links and circumstances in Mogadishu. We can't exclude the possibility that he's got such connections. he's only got to prove a real risk, but we can't make any findings about the very issue that's been referred to us to investigate because he's told a lie about it.
I mean, putting it in percentage terms, if there's, say, a 10 or 15% possibility, that's a real possibility, and if you've got no more evidence, is this your case, then the tribunal's right in saying, since you may fall within either, you can't just rely on statistics and say...
Yes, precisely, my lord. That's what we say the Court of Appeal decided in GM Eritrea, and we say that approach is correct as a matter of principle and applies here, which is why I was going to take your lordships and ladyship to GM Eritrea and to our propositions about lies, just to see how they fit together. I mean, we of course accept that it's not persuasive for us to argue, look, this is what GM Eritrea says, and it's a close enough analogy to our case, therefore we succeed. What we say rather is it's important to understand the structure of the reasoning of the Court of Appeal in GM Eritrea. If one understands that structure, it is correct as a matter of principle, and it applies and was rightly applied by the AIT in our case. Now, can I ask you to look again at the note that we provided this morning? And I'm just going to make some further points about the propositions. Now, the common factual feature shared both by GM Eritrea and our case is that there are both cases where the general evidence shows that a substantial majority of people in a particular class will be at risk on return, and the issue is what approach should a fact finder adopt where in such a case an appellant has lied on the very issue or a very material issue which would place him in the vulnerable class. Now, just looking at Proposition 1 and Proposition 2, we say those must be trite and uncontroversial. The role of the fact finder must be to consider the evidence and to evaluate it, and to attribute to each bit of that evidence the weight that he considers right. If authority is necessary for either of those propositions, then it can be found in Karanakaran. And Propositions 1 to 2 encapsulate what I've referred to as our wide submission, and we say that if the wide submission is right, the AIT were entitled to find, as they did, on the evidence before them, that the appellant hadn't proved his claim, and the Court of Appeal were wrong to interfere with that assessment. Propositions 3 and following encapsulate what I've referred to as our narrow submission, and our narrow submission concerns the position where a person has been found to have told a lie or lies on an issue which is material to his claim for international protection. Now, we say that Proposition 3 follows from the reasoning of the Court of Appeal in GM Eritrea, because in that case, the appellant in the controversial case, MY, had told a lie on an issue which was material to her claim for protection. The immigration judge had held that her claim failed, and his approach was upheld by the majority of the Court of Appeal. It's obviously right that a lie is capable of being relevant to a fact finder's assessment of the evidence as a matter of common sense. But it's also right, we say, that a lie cannot be, as a matter of law, decisive. And that's for the reasons given by Lord Justice Buxton in the minority in GM, which is at Volume 2 of the Authorities, tab 17.
I have great difficulty in a proposition that something is relevant can never be decisive. Surely, if it's relevant, it's capable of being decisive if the balance is absolutely even, absent that fact.
Your Lordship's obviously right about that. Looking at it in stages, as it were, at the first stage, a lie is relevant, of course, one must accept that, and depending on the way in which the lie is evaluated by the fact finder, of course it's capable of being decisive, as the immigration judge found on the facts of NY, and his approach was upheld by the Court of Appeal. I mean, they didn't argue with the fact that he had treated the lie as decisive, and I'll show you, Lordships, the passage in a moment. But if I could just first of all take your Lordships to paragraph 31 of GM.
Sorry, what was the reference?
I'm so sorry, it's tab 17 in volume 2 of the authorities.
Thank you very much.
So there Lord Justice Buxton is saying that the observation in two AIT decisions, Ariea and Sami and MA, and I'll take the Lordships and Ladyship to those in a minute, they're cited earlier on in the decision, that a person who's not given a credible account of his own history cannot easily show that he would be at risk as a draft evader or because of illegal exit, is with respect a robust assessment of practical likelihood, but is not expressed as and cannot be any sort of rule or law or even rule of thumb. In every case, it's still necessary to consider, despite the failure of the applicant to help himself by giving a true or any account of his own experiences, whether there's a reasonable likelihood of persecution on return. So, what Lord Justice Buxton is saying there, and this passage wasn't disagreed with by the majority, is that a lie is relevant, but there can't be a rule of law that the lie is decisive. Now, a lie is relevant, of course, because one of the reasons why a person may lie is to conceal a truth that would harm his case. And a person who has information which is likely to support his case is hardly likely to tell a lie in order to conceal that evidence. And we say it's that practical intuition which informs the dicta to which Lord Justice Buxton is referring in that passage. And there, one can find them conveniently if one just turns back in GM Eritrea to paragraphs 12 and 13. And one just takes the last sentence of the inset quotation in paragraph 12, which is from the IAT in KA, which was cited with approval by Lord Justice Richards in Ariea and Sami. Persons who fail to give a credible account of material particulars relating to their history and circumstances cannot easily show that they would be at risk solely because they are of eligible draft age. And then there's a similar passage cited from paragraph 449 of MA, another AIT country guidance case. Final sentence. Nevertheless, where a person has come to this country given what the fact finder concludes, according to the requisite standard of proof, to be an incredible account of his or her experiences, that person may well fail to show that he has exited illegally. So we have a position where it's recognised in the authorities, and we say it's right, that a lie is capable of being relevant in the fact finder's assessment. Now, a lie can't be decisive as a matter of law, we say, for two reasons. Firstly, for the sorts of reasons that are recognised in what may be the rather familiar Lucas direction, which Crown Court judges give in criminal cases, because there may be a variety of reasons why a person tells a lie. A person may tell a lie to conceal the truth, he may tell a lie to bolster his case, he may tell a lie because he's embarrassed about the truth. There are all sorts of different reasons why a person may tell a lie. So you can't have a rule of law that a lie is decisive. It's for the fact finder to evaluate why it is that the lie is being told. And so not every lie is capable of being decisive. The second reason why a lie can't be decisive as a matter of law is given by Lord Justice Buxton again in paragraph 29 of GM. He refers first of all to concerns that have been expressed in the courts about people who have relied on the asylum system, having misused it in the past. And then he says, however, that consideration cannot in itself weigh with us because the obligation of the court is to respect the international obligations of the United Kingdom towards persons who do in fact fall within the protection of the Refugee Convention, however little such persons may have assisted their case by lying or acting in bad faith. And then he refers to Mabanga and Denayan. We endorse that approach by Lord Justice Buxton, and we say that that's an extremely good reason why a lie cannot be decisive or be treated as decisive as a matter of law. If I could then move on to Proposition 4. What we say in relation to Proposition 4 is that one of the jobs of the fact finder is to decide precisely why it is that the appellant has told the lie. In other words, applying the Lucas direction, has the person told the lie in order to conceal a truth which would damage his case, or is there some other reason for telling the lie which is irrelevant to the strength of his case? If the assessment of the fact finder is that the lie has been told in order to conceal a truth which is damaging to the appellant's case, then we submit that as part of his overall factual assessment, he's entitled to treat the lie as relevant or decisive. And that's the approach of the majority of the Court of Appeal in GM Eritrea. Because as we summarise it in our printed case, in effect, Lord Justice Buxton in the minority adopted a probabilistic or statistical approach. He said, come off it, the statistical evidence shows that it's highly unlikely that this particular appellant would have exited legally. Therefore, she will be at risk when she returns. And the approach of the majority was no. The immigration judge rejected her claim. He, in effect, treated the lie as decisive, and he was entitled to do that. And we say that's explicit if one looks at the judgment of Lord Justice Dyson, as he then was, in the majority. The judgment starts at paragraph 59. If one looks at the last sentence of paragraph 60, one sees this. Although the judge, this is the immigration judge, said at paragraph 37 that in reaching his decision he considered all the evidence that had been presented to him, it is clear from paragraph 38 that he regarded the lack of credibility in M.Y.'s account as determinative of the question whether her departure from Eritrea had been illegal. And then if one looks at the last sentence of paragraph 61 in that judgment, one sees this. Her failure to give a credible account of those facts may lead to the conclusion that she has not shown that there is a reasonable likelihood that her exit was illegal. In that passage, Lord Justice Dyson, as he then was dealing with the generality of cases. And we say it's clear from those two passages and from the decision of the majority that on some facts it will be open to a decision maker to treat a lie as decisive, and in doing so he will not err in law. If one then goes back to paragraph 45 of Lord Justice Buxton's judgment, we say here that there's a clue with respect to an error in his approach. He says, finding the appellant has failed to show that she left Eritrea illegally is based entirely upon, and was seen as following from, the fact that MY herself had given no credible evidence as to the means by which she left Eritrea. To regard that as conclusive upon the issue that the court has to decide is with respect to make the error identified in paragraph 31 above. Now, you'll recall that what Lord Justice Buxton was talking about in paragraph 31 was the fact that you can't have a rule of law that a lie is decisive. But of course, the immigration judge in that case did not fall into that error. He didn't say, I'm bound as a matter of law to treat this lie as decisive. What he did in his overall evaluation of the facts was to treat it as decisive, which we say is a different thing.
Now it's 1:05.
Oh.
We'll adjourn until 2:05.